Satya Pal Jain ji, I wanted to come to you next, because legally what happens now to the disqualification proceedings that's supposed to take place after the 11th or the 12th of the month, is that still something that could take place?
See, the disqualification notices were issued by the Deputy Speaker, against whom there was a disqualification no confidence motion. The Honorable Supreme Court said, we will hear this case on 11th of July. Until 12th, the Deputy Speaker, the time for filing the reply has been extended.
Right.
Now there is a new scenario. Now the government has been formed. They will be seeking the vote of confidence. And when they seek the vote of confidence, naturally the Speaker will also be elected. So the proceedings which are pending before the Deputy Speaker only because the Speaker is not there, and the moment you elect the Speaker, then this will be automatically going to the new Speaker.
Correct.
So it will be now up to the new Speaker who will have to take a decision.
So presumably, sir, and I know that speakers are meant to be independent, but the fact of the matter is that you have a new government, they will be selecting the Speaker, and therefore the fate of that disqualification proceeding, it might be thrown away. I mean, he can say that there is no disqualification proceeding because the Shiv Sena remains.
May I just clarify one thing? As a lawyer, I am telling you, till this date, the Shiv Sena MLAs 39, 40, whatever they are, they have not done anything which may fall within the mischief of anti-defection law. Till this moment, they have never said, we are leaving Shiv Sena. They are saying, we are the Shiv Sena. We are in majority. Kindly remember in 1969, when Mrs. Indira Gandhi revolted against the official presidential candidate of the Congress, Neelam Sanjeeva Reddy, and she supported Mr. B.B. Giri, who was contesting against the Congress, since the majority had gone with Mrs. Gandhi. Even at that time, ultimately, the law found that it is her party which is the real Congress side.
No, but sir, there's a counter argument to that. The counter argument is that to this particular Speaker, the original office bearers of the Shiv Sena under Uddhav Thackeray were given. Right? The Chief Minister's name was Uddhav Thackeray, the Chief Whip's name was somebody else, and therefore, if that reality has changed, then why shouldn't disqualification proceedings start?
That is what I am submitting. They have not violated any whip of the party on the floor of the House. They never voted against the whip issued by two issues. Number one, whether the Mr. Chaudhary could issue the whip or not is one question. Number two, they have not violated on the floor of the House.
No, but they violated by anti-party activities, by going to another state, by defying the Chief Minister, by getting a Chief Whip of their own. That is not what Uddhav Thackeray wanted.
No. Within a party, the democratic right of the members to elect a leader is there. Don't forget, even after the Lok Sabha elections, the whole nation voted for Mr. Narendra Modi as the Prime Minister. In 1980, they voted for Mrs. Gandhi as the Prime Minister. Still, it was the parliamentary party which met and elected them the leaders. And when Mr. Modi was elected as leader by the parliamentary party, only then he was invited to form the government. So parliamentary party has the right to elect a leader.